Now back to the show. This is The Law Show on CL 650.
Welcome back to the program. Nice to have you with us this Sunday morning. Scott Stanley and Bill Dick are with me in studio. They are both from Murphy Battista, LLP, a longtime Vancouver personal injury law firm located downtown at 650 West Georgia Street up there on the 20th floor. Bill, you're the new guy with the firm. You've only been with Murphy Battista for a month or a little more than that. You're up in the Okanagan working out of Vernon or Kelowna?
Working out of Kelowna.
Okay, now will there be a Murphy Battista branch or satellite office, or is there already in Kelowna?
There already is. It's up and running downtown Kelowna on 215 Lawrence Street. We have a nice new office, new furniture, new paint job. Murphy Battista sign up in Kelowna.
Okay, and I would assume then that would mean that there is sufficient business coming out of that region of the province to justify the expense of opening an office in that area.
Yeah, no, there's certainly there's a fairly sizable population in the Okanagan.
Sure.
And there's, just like Vancouver, a few bad drivers. and so there's lots of claims.
Last traffic accident I was in downtown Kelowna. As a matter of fact, about 4 years ago. I was on holidays. Talk about ruin a vacation in about 15 minutes flat.
You were probably hit by a Vancouver driver, though.
No, a local guy in a pickup truck. I got all banged up. He had a little scrape on his front bumper, one of those old Chevys.
Oh, yeah.
Anyway, yeah. I wouldn't have had to see you because I was okay as a result of it. But I wanted to come back to you, Bill, and before we talk a little bit more about business in the interior and the reasons for the expansion the firm has decided to do, I want to go back to that life-changing trial you went through with the young couple from Ontario.
Okay. They
were back out here. You put them up at your house.
Yeah.
I wanted to know how it came out. You said it was a 10-day trial. It was to do with liability, who was at fault. And had this couple lost, the insurance company had threatened them, they would be obliged to pay costs, which could cost significant, if not silly, amounts of money, which for a young couple with the first child on the way would have probably ruined them. So how did the trial, or how did the case work out?
Yeah. And just in terms of how that works, we have a system in British Columbia where costs are awarded to the party who's successful.
Okay.
So in this particular instance, if that young couple had lost on liability, then they would have had to pay the costs of the defense to run the trial.
Okay.
And it can be prohibitive if you lose on liability. So in this particular instance, we weren't able to resolve the claim because there was a huge contest in terms of what would happen if we went to trial on liability. ICBC took a position that our client was at fault, and we took the position that the other driver was at fault. And it's an intersection case. Oftentimes, intersection cases can go any way in terms of liability. But at the end of the day, the judge found that the defense driver was 80% at fault, and our client contributed a small portion of 20%.
Okay.
So that was a significant, from our perspective, victory for our client.
Okay, and so once that level or degree of liability is established, is that the end of it, Bill, or does it then go on to a damages awards level?
Well, ICBC weren't happy with the result of the trial decision, and they actually appealed the decision. So we had to go to the Court of Appeal, which took about a year to resolve that. We were successful at the Court of Appeal to uphold the trial judge's decision.
Right.
And then we had to deal with quantum. So the reason why we went to a liability trial was because that was the big impediment to resolving the claim. We couldn't agree.
As to who was at fault?
Who's at fault.
Okay.
So until that got resolved, we couldn't even talk about the quantification of the claim, what the value was of our client's injuries.
Okay.
So until it actually went to the Court of Appeal, and we got the decision from the Court of Appeal, then we could deal with quantum.
Quantum
and that was,
meaning, what does that mean?
Quantum meaning, what is the value of the claim?
Okay. Okay.
At the end of the day, what pain and suffering and wage loss
Sure.
and things of that nature, what's the value of it? That was hotly contested too, and that actually almost got to trial before we resolved it. So the whole process took years, unfortunately, but we ultimately were able to resolve it without going to a second trial for quantum.
One important factor about Murphy Battista, Scott, that you and I have identified numerous times, and it's been a pleasure to do the same thing with both Joe Murphy and Joe Battista, is the fact that every lawyer in the firm goes to court a lot. And this speaks volumes as to the success level the firm enjoys. You aren't afraid to go to court. It's part of what you do. It's part of what the mission you've chosen. So when a person is in a personal injury situation looking around for a lawyer, I would think that they would want to know and feel comfortable that whoever they choose, should push come to shove, can get into court for them and do a heck of a job. And I know there are lawyers who don't go to court ever in their careers. Do some of them find their way into personal injury law?
I think there are some lawyers that do personal injury work that don't go to court, or they don't like going to court.
I know.
And
I have a friend who just would prefer to have just about anything inflicted upon him rather than put on the gown and go to court.
It's a mindset. But from our point of view, every file in the firm is going to be prepared as though the case will go to trial.
Right.
And for many reasons. I mean, firstly, as the lawyer, we don't know which case will go to trial. And when we lay our heads on our pillows at night, we don't want to have a worry that a case is not prepared properly. So it gives the lawyer peace of mind. And if a case is well prepared, you're more likely to get a good result from the insurance company because you're obviously prepared. You've demonstrated that to them.
Right.
And they can tell the difference between a lawyer that's going to go to trial and not, just simply because the case is either prepared or not.
Right.
And then when it's in the client's best interest and they instruct us, then we are more than happy to take a case to trial. It's probably makes little economic sense for us to take a case to trial because you make more money by settling a case than you do by taking it to trial. Mm-hmm. But what we have found is that it raises the value of all of the files in our firm's portfolio if we'll take cases to trial. We may not make money on that particular case, but overall it raises the settlement value of all the other cases.
And it doesn't hurt the firm's reputation one little bit either. And I use the word, and I've used it sort of tongue in cheek in the past, but you guys are gunslingers. When necessary, you'll go to court and do the job that's required. And I think the opposition understands that about Murphy Battista too. So when a client is of yours goes up against one of these big insurance companies, they know that client has legal representation that isn't in any way afraid of anything that insurance company's going to try.
I think so. The more cases that you take to trial, ironically, the more likely you are going to be able to settle the next case on favorable terms.
Okay. Bill, I wanted to ask you, because you've just opened this whole business about the liability trial where someone was found to be 80% at fault and the other motorist to be at 20. This is something that is confusing for British Columbia drivers. A lot of us are under the impression that we live in the land of no-fault insurance.
Right.
So if that's where we live, Bill, why is it important to determine fault? Where does this fault, no-fault thing, how does that shake out? Most of us are confused.
Well, I can tell you that we are not a no-fault province. There are provinces, Saskatchewan and Manitoba being two, where there is what's called a no-fault system, where if you're injured, regardless of who caused the accident,
right,
you will get some amount of money based on some system that they have for compensation. In British Columbia, Alberta, we have an at-fault system where in order to get compensation on a tort claim being a claim where you sue someone who has injured you, you have to find fault. You have to actually find that their actions have caused you on a basis of fault.
Well, then, so why are so many of us confused about this no-fault business? Is it partly because it's compulsory government insurance that we have no option out of, and so we kind of assume that that's part of the package?
Well, to make matters more confusing is everyone has a policy of insurance with ICBC.
Yes.
And if you are injured, you get benefits through your own insurance policy. They're called no-fault benefits. That's where the confusion often comes into play.
Yeah.
So if you're hurt, even if you're the one who caused the accident, you have your policy of insurance with ICBC, and they have regulations called Part 7 no-fault benefits.
All right.
Where you can get some rehabilitation, you can get some disability payment for wage loss. That's all prescribed in legislation. They're called no-fault benefits. So everyone who has a policy of insurance or a driver's license has access to these no-fault benefits. But that has nothing to do with the tort side when you sue a driver who has injured you.
And who was clearly at fault, thus the suit.
Yeah, and if they weren't at fault, you don't get any money on the tort side.
So what happens then, and this is kind of an oddball question, but what happens in Manitoba or Saskatchewan, Scott, where they really have the no-fault stuff? Do people sue each other when fault doesn't matter?
Well, we have claims all across Canada, and we've got clients that have, from BC that have been injured in other provinces.
Sure, of course,
and
yeah.
So we deal with this routinely. And in those jurisdictions, there is some opportunity to sue a responsible driver if, for example, they've been intoxicated, or there is some other threshold that needs to be met. But they're very, very narrow opportunities to sue people, and when they're not, and we're trying to help our clients locally, get at benefits in these other jurisdictions, they're without any remedy. Like, I've seen these no-fault insurance companies do things that they would never pull here, acting in bad faith, things that they would never get away with here because a lawyer can go to the court and seek redress. But in these other jurisdictions, that's just not possible.
Okay.
There's nothing to police the insurance companies in those jurisdictions. In BC, we have the best system, I think, in North America, because everyone gets a base layer of no-fault benefits for protection. And then if you can establish fault, then you can get all your benefits. Or all your compensation. So I think we have the best system in North America.
We hear it now. Now, you're talking about Murphy Battista having clients and representing cases in multiple Canadian jurisdictions. What happens if you're dealing with a client who has been on vacation, maybe down Spokane or Seattle or whatever, and they get banged up and there's a problem with an American driver and an American insurance company? How do you deal with that person who's a Canadian, Bill, who might just live down the street from you in Kelowna? How does that person get represented?
I probably have about 8 or 9 files right now where my clients were injured in the States. Hawaii, and I should go there and investigate that claim.
You should.
I absolutely should. Oregon.
He could use the sun.
Washington State, and it's a real challenge. And one of the reasons why it's a challenge is that you have to commence the action down in the States. Even though you're representing the person, you often have to hire a lawyer who's down in the.
I was just going to say, you couldn't show up at a courtroom in
No.
Washington State. You have no standing.
No,
down
not unless
there,
you
right?
get called to the Washington State Bar. And, the other usually significant issue is, unlike British Columbia, American states have very low limits, and limits of insurance. So the minimum in a lot of the states is $25,000. So they're carrying $25,000 in coverage. And oftentimes it's just completely inadequate in terms of.
I'm sorry to interrupt, but I'm just looking for comparison.
Yeah.
If an American is compelled to carry only a minimum of $25,000 in insurance, what would that Canadian driver's minimum compulsory coverage represent?
In British Columbia, the minimum coverage is $200,000. So, most people have more than $200,000, and I would encourage anyone listening to have more than $200,000. But if you're injured in British Columbia and people have valid insurance, at the base minimum, you're going to have $200,000 if you can establish fault against another driver. And what happens it gets complicated, but what happens in the States is they may have only $25,000.
Exactly.
They will throw up that $25,000, and the people who are at-fault drivers will say, we don't have any assets, and that's all we have. And then the drivers in British Columbia, we have what's called underinsured motorist protection.
Yes, of course. UMP. Yes.
UMP. We all have UMP.
Yes, we do.
So
we have the option to exercise UMP. I think most of us do.
Yeah, so what happens is you don't have adequate coverage in the States. You end up coming up to British Columbia. You got to work with ICBC and get them to accept there's no further redress down in the States. And then you have what's called an UMP claim here in British Columbia. So when Scott says we have a good system, we actually have a very good system in British Columbia that is designed legislatively to protect people who are victims of accidents and who are injured.
Okay, if that's the case, now we need to take a break. So I'm going to let our listeners chew on this one for a little bit, because they'll be interested in what you have to say when we come back. But if we have, as you both agree, we have one of the better motor vehicle insurance systems in North America right here in BC, why is it then that so many British Columbia drivers think of ICBC as the enemy? Because we think ICBC thinks of us as the enemy. It's a kind of a two-way street in which nobody appears to like each other and trust each other even less. We'll find out what the lawyers have to say about the enemy, or perhaps not, when we return here on The Law Show on CL 650.
There's more of the show still ahead. This is The Law Show on CL 650.